Hello and welcome to our discussion of trusts and gifts. I'm first going to talk about trust. We'll talk about the formation of a trust and also how trusts can be used with some basic estate planning to perhaps bypass probate, plan for incapacity, and then we'll look at a few more advanced trust options for individuals who may want to manage property beyond their death, not only for family purposes, but also for estate tax savings purposes. So let's first talk about the parties to the trust. First, we'll talk about the settlor or the grantor of the trust. That's actually a better word. I like grantor better than settlor. Settlor sounds kind of strange. But anyway, settlor, grantor, or actually creator, even. Those are three terms that are used to describe the person who's setting up the trust and funding that trust with property. So the next party would be the trustee. That's the person or the party that receives those trust assets, and they are responsible for responsible management of those assets throughout, if it's during the life of that individual, and also for distributing those assets to according to the terms of that trust document. Now, they are a fiduciary. They have that very high standard of care that they're responsible for maintaining, and so it's a very important role that they play. They can't be self-dealing, have conflicts of interest. So the trustee's looking solely for the benefit of preserving that property, managing it, and then moving it on to the beneficiaries as described or as dictated by the trust provisions. And then we have the beneficiaries. Of course, those are the parties who ultimately receive that property at some point down the way. Now, let's talk about types of trust. There are trusts that you can create while you're alive and trusts that come into life at death. Now, we've already briefly discussed the testamentary trust. Remember when I said last will and testament? Okay, a testamentary trust comes to life through the probate process when a will has been validated by the court and is administered through the court. Okay, property typically pours over into that trust. In fact, some wills are called pour over, or a will with pour over provisions, where the remainder of the trust that's not specifically going to someone through a bequest may pour over then into this trust. And those are called testamentary trusts. They occur after death or come to life after death. There are also those trusts, though, that come to life during the individual's lifetime, or we'll call it your client, during your client's lifetime. And so there are two major types of living trusts, okay? That would be the revocable trust and the irrevocable trust. Okay, those are both living trusts. Now, let me just approach this from the standpoint of following the bullet points here. Revocable, okay, yes, it has it here. Revocable living trust created during your lifetime. It can be modified or revoked. It avoids probate if properly funded. No tax savings by itself for estate purposes. So let me explain what that means. You can create the trust, or let's say your client creates the trust, and as long as they have funded that trust, put retitled property to be held in that trust, then if they became incapacitated, the trustee steps in and can manage that property, or they could have the trustee, assuming they put it in the trust, funded during lifetime, the trustee will be managing that property. And if they become incapacitated, the trustee will continue to manage that property. And if they were to pass away, or at the time that they pass away, the property's in that trust and it is distributed then according to the terms of the trust. Okay, so that's a living trust that has been funded. Now, that can be revocable or irrevocable. If it's revocable, then it means that your client, if they set up this trust, they can go back to the trustee and say, you know what, I'm dissolving this trust. I'm terminating this trust, and I'm just going to retitle the property back into my name. Okay, and so as you can see here, the individual, your client, has always had control of that property. They put it in the trust, they can take it out of the trust, okay? Now, because of that, this trust property is going to end up in their estate for estate tax purposes, okay? It'll end up in their estate. It's still going to go to the beneficiaries that are named in the trust according to the terms of the trust, and it will bypass probate as well, okay? It'll be bypassing probate. The only problem with this, though, is that at death, with respect to the amount of property that's in that trust, that's going to be counted as this individual's asset because they maintained control all the way up to their date of death. Okay, and so if they have $10 million in that trust, then that goes into their gross estate for estate tax purposes. And so even while the estate tax exemption amount may be high, just like you have a standard exemption on a standard deduction on your tax return of like, I think it's like $14,000, $15,000 now. Estates have an exemption amount too, where you can have up to $15 million of value in your estate and not have an estate tax on that. The estate tax is zero because of that huge exemption. It used to be like 600,000, then went to $1 million, then it went to $3 million. And then finally, over the years, it's been expanded up to where it's now $15 million, okay? So if this individual, however, though, had this revocable trust with $10 million in it, and they had other assets that were valued at $20 or $30 million, then they're not really accomplishing anything from an estate tax planning standpoint to have this money flowing into their estate, because the estate tax rates start at about 40% once you get past that exemption level. You're looking at very high estate tax rate, 40% of an estate being depleted. So imagine that, 40% of $10 million being depleted because it was taxed for estate tax purposes. So the bottom line here on revocable living trusts is that you maintain control, okay, throughout your lifetime. You can leave the property in, you can take the property out, but at your death, because you maintain that level of control, then that will be included in your estate for estate tax purposes. Now, for probate purposes, again, it's going to bypass probate because the trust is one way to get property to heirs and not have to go through the will. Okay, it's independent of the will. Now, what's the other point I wanted to make about revocable trusts? Oh, incapacity planning. They're great for incapacity planning because it could give you the ability to, number one, put the money in the trust or the fund the trust with property and test out the trustees, see how you like them, see how they're managing that property. And if you became incapacitated at any point in your lifetime, then assuming that trustee worked out and you were fine with them being the trustee, then if something were to happen to you during your lifetime and you can no longer manage your affairs, then you already have that trustee in place with this living trust, and that property could be managed then by them on your behalf. Okay, one other thing about that you need to know about living trusts, revocable living trusts, is that because you do maintain maintain control, I shouldn't say possession, to where you could terminate that trust, because you have those strings attached, it is going to be considered your property for income tax purposes. So on your income tax return, you're going to have to report the income that's being generated from those assets. Even though they're sitting in the trust, that's going to go on your tax return. Okay, that's the revocable living trust. I was looking on the slide to see if I could find the irrevocable living trust, but living trusts come in two flavors. One is the revocable, where I've just discussed, but then there's the irrevocable living trust. And this is where you actually do sever your relationship with the property. You're making a true gift of that property into that trust, and there are no strings attached any longer. So let's just say that you set aside $5 million to go into this trust. Let's just say it's an appreciating asset. You put $5 million worth of some business stock, maybe a closely held business. You put that into the irrevocable living trust during your lifetime. Okay. Now, one reason that a person may want to do that is because by making that gift, they're making the gift at today's dollars. And so that $5 million that will be going into that trust, that could continue to appreciate. So if it's stock in a business, that stock may appreciate to 7, 8, 10, 15 million dollars over time. What this individual has done is they've basically frozen the value for estate tax purposes, and they're not letting that appreciation continue to grow inside their estate. So by making a gift during their lifetime, they are kind of locking in that value and having it go to a separate entity to be managed. Now, it'll grow in the trust and ultimately will be distributed and taxed to parties down the road. But in terms of the individual who's trying to watch the size of their estate and manage their estate and maybe do some gifting during lifetime, they can make this gift or make this contribution to this irrevocable trust and have that property appreciating from there forward, from that day forward, outside of their estate. I'll touch on this again when I get to a chart that I'm about to discuss where I talk about a few additional trusts. So let's go ahead and move forward. Okay, I'm looking at this slide. This is something I've kind of hit on, I believe, most of these points already. But be sure to study this just to be sure that you're comfortable with the language, the advantages of trust, bypassing probate, incapacity I've already mentioned. Beneficiary protection, it says safeguard assets from creditors. It may be that by putting property into a trust, you not only protect that property from your own creditors. Now, with a revocable living trust, remember, because you still have the strings attached, and you could take that property back anytime, there's not going to be the creditor protection that you would have with the irrevocable living trust. So that would be one distinction I'd make there. With respect to your own defenses against creditors, making the complete gift is better for creditor protection. However, now you need to keep in mind, though, once you make that gift to the trust, you're not able to go back then and say, oh, I've changed my mind, I'd like to take that property back. So typically this is made as, the irrevocable living trust is less common than the standard living trust that you can always take the property back if you wished, okay? But it mentions beneficiary protection here, and that is where the beneficiaries, to the degree that they would be sued by their creditors and the creditor would be able to reach that property. If it's held in trust, the beneficiary is not able to tap into that trust. They can't just go and say, hey, I've been sued, my creditors, or the creditors can't attach the assets of that trust. I guess that's a better way to say that. And so there's creditor protection built into the trust when it comes to beneficiaries. And then finally, privacy, we've already discussed as well. So read through these. Again, it's not nothing real major here other than just to kind of give you a better feel for how these trusts are operating or the advantages and disadvantages. Okay, now I'd like to compare and contrast these trusts. First, I've talked about the revocable living trust. As you can see, we have it kind of in a spreadsheet format here. Revocable living trust, you set up during your lifetime. Another term that's used to describe revocable living is inter vivos or inter vivos. I say inter vivos trust. The inter vivos trust, it is revocable by you anytime. You do avoid probate, and as it states here, manage assets during incapacity. I haven't discussed a credit shelter trust yet. I'll do that later on because we're going to talk about an estate tax savings. Not really a strategy. It's just a process that's very common for trying to reduce or even eliminate estate taxes. We'll get to those. But there's a credit shelter trust that's used for that. Included in taxable estate, yes, it is. It says tax notes included. Because you have strings attached, it is included in your estate. And I think it says creditor protection. There it is, creditor protection. No creditor protection because you are the owner. Once you put it in a trust, you've titled it over to the trust, but you still have control. You have the ability to dissolve that trust. And because you have that level of control, creditors will be able to reach those assets as well. So there's no creditor protection with the revocable living trust. The irrevocable, again, I said you make the gifts to the trust, you fund it during your lifetime. It's an irrevocable living trust. So you can see here, you cannot revoke it because you've made a completed gift, no strings attached. Probate avoidance, yes, you're still bypassing probate. So this table, I think, is a pretty good one for you to follow, especially when it comes to studying, I guess, for the final exam. Asset protection, also afforded there. Tax reduction, meaning that you're making gifts. And where's the tax reduction coming in? Well, you're making gifts during lifetime and removing those assets from your estate. And those assets are now growing outside of your estate in a separate irrevocable life insurance trust. Because remember, it stands alone as its own entity and you no longer control the trust. Now the terms, you set up the trust to do what you wanted it to do, but you're no longer able to jump into that trust and pull those assets back out. So when it comes to tax reduction, all that appreciation, I mentioned the business interest, what did I say, $5 million, maybe growing up to 710 or greater. All of that appreciation is passing outside of your estate. So you do not have to include that on your estate tax return, or your client wouldn't have to do that on their estate tax return. Okay, a testamentary trust, again, we talked about that, springs to life at death, created by will. Good common point to understand there, we've already discussed. not revocable. You've passed, or your client presumably has passed away, and so they can't revoke it, right? The will is now coming into life, and this is where the testamentary trust comes to its life, is through that will. And that doesn't occur until after death, so it's impossible for an individual to revoke the testamentary trust because it's not even established until they've passed away. Probate avoidance, no, because you have a will that is in the probate process. And so the testamentary trust is going through that probate process and will receive those assets by pour over. We talked about the residual of the estate pouring over into the testamentary trust. So it is a part of probate. So the answer, of course, is no, it doesn't avoid probate. Now, again, it can be used for tax planning, for estate tax planning, using this thing called a credit shelter trust. It kind of takes on the role of a credit shelter. And again, I'll get to that in a few minutes. Let's move on down now. Let's see. Oh, a QTIP trust. One final trust I'd like to talk about is a qualified terminable interest trust. This is commonly used where the person who's setting up the trust wants to have some control over the property at some point after after their surviving spouse passes away. A QTIP trust can be set up by spouse number one. Let's just say spouse number one has 2 children from a prior marriage, and spouse number one's married to the spouse, their wife. Okay, husband and wife. We have husband, 2 children from a prior marriage. Husband and wife, they have a child of their own as well. So if everything from the husband's estate were to pour over into the wife's estate through the will, just say I leave everything to my wife, then who's to say, who knows whether that wife, the surviving spouse, may just say, well, I'd love for all this property to go to my child, or the child of my husband, but my child, and I've never had a relationship with the other 2 children from his prior marriage, and I just want all of my estate. I'm going to draft a will that says everything that I have goes to my daughter, or goes to our daughter. Well, the husband may prefer that his children from the prior marriage receive property. And so in order to kind of lock that down, the husband can create a qualified terminable interest trust. And if it jumps through all the hoops and follows the tax rules, then and the legal rules for the language, then that trust can be set up to actually provide for the spouse, provide for the surviving wife throughout her lifetime. But at her death, it can then dictate that property goes to the children of the prior marriage, as well as to others. And so that's an advantage of setting up a QTIP trust to receive some of those assets at the death of the first person to pass away. Okay, now we have lifetime gifts, and let's just discuss the basics. I know, again, we're pressed for time in terms of trying to get through all this material. So we'll just talk about at a very high level, reasons to engage in a gifting process. Number one is with respect to estate tax planning and high wealth clients. This is a great way to remove appreciation from an estate. I'll give you a very basic example, and that is where you have stock that you actually you're gifting the stock into a trust and having that trust hold that asset, and it goes in at the value the fair market value when you put that into trust. But again, that trust can grow now, those assets can grow outside of your estate for decades. It just depends on when you put the property in. And you may have, millions of dollars of value that is not going to be taxed for estate tax purposes once that's removed from the estate. Second is, it says teaching beneficiaries financial responsibility before inheriting large sums, making small gifts, baby steps before we get into the large steps, before we start running with the assets, helping beneficiaries understand, the importance of sound management, money management techniques, not going crazy with this money, kind of testing the waters to see just how mature the person is, and are they capable of handling a larger request later. And so you can go through a gifting program there. Asset protection, removing assets from creditor claims. Again, lifetime gifting removes that. If it's not your property, then your creditors can't come after that property. unless of course there were fraudulent transfers. There are exceptions to that rule. But again, gifting into irrevocable trusts or making gifts outright to third parties are a good way to avoid creditor attacks on that. Now, how do we make gifts and in what amounts? Well, each year your client will have an annual gift tax exempt amount where they can gift, and I think it's the 2026 number is $19,000 per donee, and that's per year. So if you have a client who just has multiple donees, let's just say they have 10 grandchildren and 5 great-grandchildren, they can make a gift of $19,000 of value to every one of those grandchildren and great-grandchildren, $19,000, and never have to file a gift tax return. Okay, also another way to make gifts is through direct payments. Direct payments to 2 different types of institutions. Direct payments for education to educational facilities like a college or a university, tuition payments, or direct payments to a healthcare system like a hospital or other healthcare system to pay for medical expenses. Now, as I said, these are, in fact, I hope it says here, yes, it does say direct payments. You can't pay the individual and tell them to go pay the university, or I can't pay the patient and say, now go pay the hospital to pay that hospital bill. These have to be direct payments made by you to the institution. And if that happens, you do not have to report that on your gift tax return as a taxable gift. And finally, I'd like to just briefly mention gift splitting. This is where you actually make a gift of more than the $19,000 amount that we have here. Let's just say it's $38,000 of some property that you own, but because you are married, you can actually file the form. In fact, here's the form 709. That's the gift tax return. You can file that form, but even though you've made more than a $19,000 gift, you can claim gift splitting. And so with your spouse's approval, you file that form and say, I'd like to split this gift, and we'll consider half of it as having been given by my spouse. And so you're able to double the gift that you made without having it counted as a taxable gift. Okay, that's all we're going to cover with respect to gifts in this class. We may come back to these when we talk about the ultra-large or the ultra net worth client and issues that they face with respect to management of their family affairs and in money and in distributing assets. But I'd like you to now go to the last section or take a break and come back to it. But this is where I have that Word document posted on As You Learn. Key incapacity planning documents. This is where these are documents that need to be executed during one's lifetime to properly manage their affairs in the event that they become incapacitated in any manner, illness, injuries, that type of thing. So we'll be looking at the living will, the durable power of attorney for health care, financial power of attorney as well for managing the business affairs, and of course the living trust. We've already touched on the living trust, but again, it's being thrown into this category because living trust is something that can really be a great instrument to take effect and have a trustee manage your affairs if you became incapacitated and needed someone to manage that money during your lifetime. Okay, so refer to As You Learn for a discussion of these documents. Thank you.